So this time, let's continue with the kinds of obligation. Let's go to alternative remedies of the creditor in case of breach of determinate obligations. So, very interesting. What are the remedies? Alternative remedies of creditor in case of breach of indeterminate obligations. So, failure to deliver the determinate thing. First is that right to compel. There are three. First, one, two, three. Right to compel. Right to compel the debtor to deliver the determinate thing due in action for specific performance with a right to recover for damages. So the very first is that right to compel under specific performance. So the very first, file an action for specific performance with the right to claim for damages. Right of action for specific performance with right to recover. And next is the right to rescind. Yes. The right to rescind in proper cases with the right to claim or recover damages also. Right to rescind obligation with the right to recover damages. And right to recover damages where it is only the feasible remedy. So right to recover damages when it is only the feasible remedy. So very first is that for specific performance, the right to compel the creditor or the obligor to deliver the specific thing with proper damages because there is already incurring of delay, negligence, diba? Fraud. Next is to rescind or rescind with improper cases. So later, when to rescind, diba? With required to recover damages also. Next, when the right to recover of damages is only the feasible remedy. Only feasible remedy. Next, so we are done with indeterminate thing. These are the that's for indeterminate thing, in which a determinate thing wherein the creditor right to the fruits, right to demand the fruits, shall be from the time the obligation to deliver that the indeterminate thing arises. So again, the creditor shall only be entitled to the fruits wherein from the moment the obligation to deliver arises. The creditor has the right to the fruits, from the moment it demands the delivery of the determinate thing. And the obligation to deliver the determinate thing arises at the time of the perfection of the contract. Diba? As a general rule, the obligation to deliver the determinate thing only arises from the time the contract is perfected, except when the obligation depends upon the happening of a suspensive condition, wherein such condition arises only upon the happening of the such suspensive condition. Fulfillment happening of suspensive condition gives rise to an obligation to deliver the specific thing. But if the delivery of the specific thing depends subject to the term or period, therefore it must be understood that the right of the debt creditor to the fruit must be from the moment the vinculum attaches or upon the contract is executed, or perfection of the contract, upon the perfection of the contract. So remedies of the creditor in case of failure of the debtor to deliver the determinating is to file for specific performance, to compel the delivery of the thing with the right to recover damages, right to rescind in proper cases with right to recover damages, and also right to recover damages if this is only the feasible remedy. The specific thing has already been damaged, cannot anymore be repaired, damage, so therefore damages can be recovered as the feasible remedy. Next, indeterminate or generic obligations. How is that? indeterminate or generic obligations. When considered generic, when can you consider an obligation is generic? When? In remedies in case of breach. When considered generic, a thing is generic if it has been designated merely, not particularly designated, um, designated merely by a class or genus, diba? Only a class or genus. Remedies in case of breach. In case of breach of generic or indeterminate obligations, the following are alternative remedies of the creditor. Always take note that genus ng quam perit, or in genus never perish. The loss or damage on the indeterminate thing will not extinguish obligation. So, these are the alternative remedies of the creditor in case of breach. Remedies in case of breach. 1, 2, 3. The very first is that, okay, right to compel the debtor to deliver the thing with right to recover damages. The same. Specific performance, di ba? Deliver the thing. Compel the debtor to make delivery with the right to recover damages. Next, right to ask another person to make the delivery at the expense of the debtor with a right to recover damages. So, right to ask another person to make delivery at the expense of the debtor with a right to recover damages. Next, right to rescind the obligation in proper cases with right to recover damages. So, these are the remedies when it comes to indeterminate or generic obligations. Right to compel the debtor to make delivery with right to recover damages. Right to ask another person or third party to make delivery at the expense of the debtor with the right to recover damages and also to right to rescind the contract or the obligation with the right to recover damages. So that is for indeterminate or generic obligations. Next, positive personal obligation and negative personal obligation. We will be going to positive personal obligation, negative personal obligation, and the remedies of creditor to protect or enforce his credit. When can we consider that it is a positive personal obligation? As a review, positive obligation, it's the obligation to do, diba? It's obligation to do or not to do, that is personal obligation. And it is subject to involuntary servitude as stipulated in the Constitution when a person is compelled to do something that is beyond from the skills, that is beyond from his skills, his or her skills. So therefore, it is already involuntary servitude. And the law does not allow that. The law does not allow that. Next, when considered breach, positive personal obligation, when considered breach, if the debtor fails to do the obligation, or even in case of performance but the same is done in either in a poor manner or in contravention of the tenor of the obligation. Okay? Poor performance done in a poor performance or in contravention to the tenor of the obligation. That is, when the contract is to make a repair but the result is not a repair but to worsen that thing, therefore in contravention to the tenor of thereof. In contravention to the tenor of the obligation. No compulsion of debtor. No compulsion of debtor In case of breach, this is take note that there is no compulsion of debtor. In case of breach of an obligation to do, the creditor may not compel. In case of breach of an obligation to do, the creditor may not compel the debtor to perform act required against the latter's will. The creditor may not compel the debtor to perform acts which is act required against the latter's will. The creditor may not compel the debtor to perform the act required against the latter's will, against the debtor's will, because the same amounts to involuntary servitude, which is prohibited by the Constitution of the Philippines, and such compulsion may amount to coercion. Such compulsion may amount to coercion, which is penalized under the revised penal code. Remedy in case of non-performance. What's the remedy in case of non-performance, di ba? Siyempre, let the debtor do the act at his expense, di ba? In case of non-performance of an obligation to do, the creditor is entitled to ask another person at the expense of the debtor. The remedy of the creditor in case of non-performance by the debtor is to ask another person to perform the obligation and to have the cost thereof charged against the debtor. So at the expense of the debtor, to have the cost thereof charged against it. If in the original contract, if the debtor is to make a repair but it worsened, therefore the creditor may ask another person or third party to make a repair, and the payment or expenses for the repair must be charged against the debtor. In addition to his right to recover damages from the debtor. In addition to his right to recover damages from the debtor. So, ask another person to make to perform the obligation and to have the cost thereof charged against the debtor. And second is to try to recover damages with the debtor. But if the personal qualifications of the debtor have been taken into consideration in the constitution of the obligation, yes, in which only the debtor can do the obligation, this remedy as unveiling, in which case the only remedy of the creditor is to demand payment of damages from the debtor. So again, but if the personal qualification of the debtor have been taken into consideration in the constitution of the obligation, in which only that debtor can or only that obligor has the personal qualification to do, but only that obligor has the qualification to do or to make a repair as consideration in the as considered in the constitution in the formation of the contract, then the remedy is unavailing. This remedy in which asking another person is unavailing, in which the only remedy of the creditor is to ask for recovery of damages from the debtor. Additional remedy. Additional remedy to demand undoing. In cases where the performance of the obligation is done in a poor manner or contravention of the tenor of the obligation, the creditor has an additional remedy of demanding for the undoing of what has been done if the same is still possible at the expense of the debtor, in addition to his right to avail remedies mentioned in section 15.3. So again, diba, in case of the performance obligation is done in poor manner or in contravention to tenor, has a, the creditor has an additional remedy of demanding for the undoing what has been done. Demanding for the undoing. So therefore, the remedy of the creditor, it's to perform the undoing. The creditor has an additional remedy for demanding the undoing of what has been done in case of a poor manner or in contravention. Example, if the painter in the contract, diba, a repair of a typewriter, the contract there is to make repair, but it worsen or it attach another parts that is incompatible, that is not fit to the machine. So therefore, the creditor, in addition to ask another person, the creditor also can demand the obligor to remove those parts that is not fit, that is not proper to the machine. Diba? Again, these are now the remedies of undoing. First is that the debtor fails to do the if the debtor fails to do the obligation or there is non-performance on the part of the obligor, therefore the creditor is entitled to ask another person for the performance, for the fulfillment of the obligation at the expense of the debtor. But if the personal qualification of the obligor has been considered during the constitution or constructing the contract, then therefore the remedy of asking another person is not availing or unavailing. Therefore, the only recovery of damages is only feasible as a remedy. And at the same time, in addition, the creditor may demand the obligor to make, to restore, or to make, to demand for undoing what has been done. Undoing, remove those parts that is not fit for the machine, to return it to make a return into its original state, demanding at the expense of the debtor. Now, let's go to negative personal obligation. Nature of creditor's right. The right of the creditor is not to demand an act but an omission. The right of the creditor is not to demand an act but an omission. But here, in negative personal obligation, the creditor or the obligee forbids or prohibits the obligor to do something. In negative personal obligation, the obligee prohibits or prevents the obligor. The obligee prevents the obligor to perform acts. So, here, the right of the creditor is not to demand an act, but an omission. And its non-fulfillment consists in executing the act of which the obligor is forbidden to do. Yes, forbids to do. Obligor is forbidden to do. Non-fulfillment of consists in executing the act of which the obligor is forbidden to do. Remedies of creditor. Remedies of creditor in case of breach of obligation. So what's the remedy? If the obligor does what he is forbidden to do, the creditor may demand the undoing of what has been done at the expense of the obligor. in addition to the creditor's right to recover damages. If it becomes physically or legally impossible to exercise the right to demand of undoing of what has been done, the remedy, therefore, is to recover only for damages. Demand the undoing. First, the creditor or the obligee may demand of the undoing what has been done at the expense of the debtor in addition to the creditor's right to recover damages. If undone, if there is impossibility, legally impossible to exercise the right to demand, therefore, recover only damages. As always, right to recover damages is only feasible. If if there is already legally impossible or becomes physically or legally impossible to exercise the right to demand. So therefore, right only to recover damages if it becomes legally impossible to exercise the right to demand. Next, remedies of creditor to protect and enforce his credit. What are those remedies of creditor to protect and enforce his credit? The creditor may avail of the following remedies in the order mentioned. Okay. To exhaust the properties of the debtor, to be subrogated to all of the rights and actions of the debtor, save those which are inherent in his person, action subrogatoria, and to impugn all the acts which the debtor may have done to defraud him, action Pauliana. The second and third remedies, however, are subsidiary to the first. How is that? Remedies. These are now the remedies of creditor to protect and enforce his credit. Enforce his credit, but to claim his credit. So therefore, to exhaust the properties, the very first is that, by example, in a case of contract of loan, creditor lend the debtor 500,000 pesos, half a million, in to be paid installment, but series of months were not anymore being paid. So therefore, the first remedy of the creditor is to exhaust all the properties of the debtor. Exhaust all the properties of the debtor. So the house of the debtor, the transportation vehicle, the communication, the phones, real properties will be used to pay for the credit. Next, or to be subrogated to all of the rights and actions of the debtor. How is that? To be subrogated. To be subrogated to all the rights and actions of the debtor, save those which are inherent in his person. It means to say the creditor will be in the right of the debtor. How is that? Example, if the debtor is entitled to a something, except those inheritance, save those which are inherent in his person. If the debtor is entitled of something, example, entitled of insurance proceeds, entitled to a shares in a corporation, in a stocks, diba? Shares of stocks, has a shares of stocks in a corporation. Therefore, the creditor will subrogate the debtor. So all the rights, all the rights that a debtor, all the rights that a debtor may have from a corporation, may have from an insurance company, it will now be transferred. The rights of the debtor will be transferred to the creditor. So now the creditor will have the rights over the proceeds from an insurance company and a proceeds or shares from a corporation. Diba? The creditor is now in the shoes of the debtor in order to enforce the claim of the debtor, of the credit rather, in order to enforce the credit of the creditor. Next is to impugn. Impugn all of the acts. How is that? Impugn, to impugn all of the acts which the debtor may have done to defraud him. Action Pauliana. It's to impugn all of the acts which the debtor may have done to defraud him. It means to say the debtor, the creditor, is now alleging that the debtor defraud him. Diba? There is fraud applied by the debtor. The debtor defraud the creditor. Action Pauliana. The second and the third remedies, the second and third remedies, however, subsidiary to the first. The very first is that to exhaust all the properties of the debtor. Subsidiary on that, subsidiary, the very primary remedy is to exhaust all the properties. Subsidiary or connected to the exhaustion of properties, these are the two. Subrogation, the creditor subrogates the rights of the debtor, and creditor may allege that the debtor defraud him, diba? In order to obtain a credit. Again, the very first is that exhaust all the properties of the debtor. Attached to it subsidiarily remedy is subrogation. Creditor becomes the debtor's right, is in debtor's right to claim all proceeds, fruits, shares, and also creditor may allege that there is the fraud made by the debtor in order to obtain credit from the creditor. There is estafa, fraud has been applied. Malicious, being malicious. So to impugn all of the acts which the debtor may have done to defraud him. So those are under the personal obligation, personal obligations.